Right now on the Daily Debrief, the Georgia Supreme Court puts the case against the accused killer of a beauty queen back on track. Also, verdicts in the case of a California man accused of murdering an entire family. And a former NFL player waits for a verdict in his own sex crimes trial as deliberations push into a second week. Plus, a father convicted of murdering his 5 kids seeks to save his own life. The Daily Debrief recaps the day in court. It's Monday, June 10th. Welcome to the Debrief, everybody. Glad you're with us. We have a lot to talk about, including a guilty verdict in a California trial which lasted 5 months to the day and resulted in 22 hours of deliberation. The jury convicted Chase Merritt of murdering all 4 members of the McStay family. Prosecutors had his DNA in a couple of places inside the family's vehicle, but Merritt says that's because he and victim Joseph McStay had lunch shortly before the family disappeared. The defense found a series of unknown DNA samples inside the family's graves. They're not from the defendant or the victims, and no one knows who they're from. Still, here are the verdicts.
We, the jury, in the above entitled action, find the defendant, Charles Ray Merritt, guilty of the offense of murder in the first degree in violation of Penal Code Section 187A of Joseph McStay, dated June 7th, 2019, 4-person. Title of court and cause. Verdict. We, the jury, in the above entitled action, find the defendant, Charles Ray Merritt, guilty of the offense of murder in the first degree in violation of Penal Code Section 187A of Summer McStay, dated June 7th, 2019.
And the verdicts for the children went on from there.
What I do?
During closing arguments in this case, the state claimed Chase Merritt shut off his phone during part of his alleged crime to evade detection. The defense countered with this.
The DA in this case has hidden the truth from you, and they set out on a course to hide the truth from you. You heard from Brian LaRocque. He testified about PayPal records, and you also heard from a representative from PayPal, Sarah Kane. Not Joseph's PayPal records, although you heard about those too. I'm talking about Dan Kavanaugh's PayPal records. Do you realize, ladies and gentlemen, that the prosecution never even requested those PayPal records? Do you realize that law enforcement, Sergeant Smith sitting here and his team, never even requested his PayPal records? So they didn't know that Dan Kavanaugh had diverted payments from the production business online to his own account. They had no idea because they never requested it. Even more shocking, they never requested Dan Kavanaugh's bank records. Dan Kavanaugh, on February 10th, either the day after or the day of, he makes the call for a welfare check on his friend, Joseph McStay. He's dipping into his PayPal account and stealing Joseph's money. Did Mr. Kavanaugh think that he wasn't coming back? I mean, Mr. Kavanaugh had to have known when he was dipping into that account and swiping $13,000 right off the bat that there's going to be a problem when Joseph gets back, unless you know he's not coming back.
Ultimately, those arguments about the alternate suspect, Dan Kavanaugh, did not win the day. This case has been littered with delays, fights between the attorneys, and changes in theories. Investigators long believed the McStays were killed at home. By the time the rebuttal came around, prosecutors claimed they never supported that theory and even became wishy-washy on the time frame.
That defense counsel and I and the prosecution team are both in agreement on is that something happened in that house. Our versions of what happened in that house are very different. They want to say that we have said they were murdered in that house. Nobody has said to you that they were murdered in that house. Nobody from the prosecution team has stood up here and said to you, all 4 of those people were murdered in that house. The defendant got control of that family and got them out of that house. They're saying the people's theory is that the bodies were buried on February 6th. Nobody has ever said that to you. Nobody has ever sat here and told you the bodies were buried on February 6th. What we said is that the defendant's phone pinged off of a tower next to the graves on February 6th. Why would he go up there on February 6th? Well, if he buried them before and we have these heavy rains, maybe he needed to go check and make sure that they were still buried.
Okay, attorneys Paula Nateri and Michael Bryant are with me tonight to digest this verdict. And Michael, it's giving me indigestion. So what's going on here? You said on Twitter this was a weak state case.
Yep.
Elaborate.
Sympathy. I mean, I think if Dan Kavanaugh had been sitting there in the defense chair, he would have been found guilty. Anybody that they could loosely tie to these murders was going to be good enough for this jury to fill in some holes and give this family and the victim's family the justice they felt they deserved.
Paula, do you agree?
I do agree. I think unfortunately, it's purely circumstantial, and I just have a lot of problems with their shifting theory. I mean, this is proof beyond a reasonable doubt. You don't get to change your theory midway through the trial and come out in the end with a completely different theory.
Well, look, the prosecutor said, oh, wait a minute, we didn't have that theory. It was just the police who had that theory. But bottom line, Michael, the jury must have had enough to bite on here. What might have been the key pieces of evidence for the jury to sort of hang this as being a conviction?
Well, certainly all of the bookkeeping issues was worth exploring. Then you have to get past, well, would you kill 4 people for the money involved here, $40,000? Well, if they believe that that fight took place between the defendant and McStay, Joseph McStay, then the rest was collateral damage. Maybe that gets them there.
Okay, we also had the DNA in the car, we had the phone, we had the money. But look, I mean, business people exchange money back and forth all the time. I didn't think the money was that strong. Maybe the DNA in the car was enough, and maybe the lunch excuse was not strong enough.
And the video, I mean, the video, I think, the video showing the car, you know, right before the time when they were last seeing the family, I think that was something that maybe the jury relied upon.
You're talking about the defendant's truck.
Yeah, the defendant's truck.
Okay,
yeah.
so again, it's a big question. Was that really his truck?
I mean, anyone, you know, I mean, if you put any particular person with these set of facts, it's just not compelling evidence. I mean, it's just not proof beyond a reasonable doubt. I mean, I think the motive, I mean, this Dan Kavanaugh had the same motive. I mean, he's dipping into, this is a case where it's going to linger on appeal. You can be sure they're going to find more evidence, and all of the evidence which the government didn't, the prosecutors didn't seem to gather, which the defense lawyers were talking about in their closing. I think this is going to linger on, and I don't think, despite whatever happens, it's going to be another trial. There's going to be something more. We'll
have to wait and see. Paula, Michael, we'll be back to you in a couple of minutes here. The Georgia Supreme Court has ordered that a case move forward against a man accused of killing a beauty queen there.
Ryan Duke and a co-defendant are accused of killing Tara Grinstead. In a 38-page opinion, the Georgia Supreme Court unanimously ruled that Ryan Duke did not have the legal right to pause his proceedings to request state money for experts and an investigator. Generally, the state does provide help for poor defendants, but in this case, Duke is not represented by the public defender. His trial judge agrees that he's poor, but he has private attorneys representing him for free. That's the legal issue. The Supreme Court left open the possibility that Duke might be able to ask for state money in the future, but said he could not do so at this stage in his proceedings.
And so that case moves forward with a trial without the experts the defendant wanted. A California jury is deciding the fate of Kellen Winslow II, a former NFL player accused of rape and other sex crimes. 5 women took the stand to accuse Winslow of the crimes listed on your screen, some in multiple counts. The jurors asked for additional evidence as to accuser number 3. They also wanted a readback of testimony from accuser number 4 and one of her friends. The so-called Jane Doe number 4 said she was 17 years old when she says she was attacked by the defendant and by his friend named Matt.
I opened my eyes and my face was being pushed into Matt's groin area.
Where were you when you woke up to that, or when you came to?
Was it a bedroom? On a bed?
You remember if that was upstairs or downstairs?
I don't know. I don't remember.
Do you know how you got from the couch to the bedroom being on a bed?
No.
What was Kellen doing at the time that he was pressing your head towards Matt's groin area?
He was penetrating me from behind.
Was he having sex with you?
Yes.
Was was he having sex with you at the time that you regained consciousness?
Yes.
That is what the jurors asked to hear late last week. And this as well on cross-examination, the defense pointing to a prior sexual encounter between doe number 4 and the defendant, which appeared to be consensual. The defense also asked about drinking.
It was because his father was an NFL football player, or famous football player, that's the reason you didn't think anyone would believe
It
you?
was more, I was a 17-year-old drinking underage, and the fact that I had messed around with him 2 weeks prior, why would anybody believe me?
Okay. Did you think that you might have, that you did anything to cause any of this?
No.
Okay. But you wouldn't know, if you blacked out, you wouldn't know anything that happened during the blackout, right?
Correct.
You would agree with me that when you say escalated, it means that you were essentially part of it from the start?
I don't know.
Okay.
The fact that I said stop.
Right, I understand. But, once again, your words were escalated, and I'm just wondering why you would use that.
Because it escalated to a point where somebody's penetrating me with their fucking penis.
Okay. So,
When somebody tells you to stop, you stop, okay? Regardless of whatever I may have
said
said. I don't know what I said.
or done. I mean, I'm just saying, look, you don't remember very much of a particular segment of the evening. That's true, isn't it?
Yes.
And that, we don't know how long that segment is, whether it's 2 minutes or 2 hours, we don't know, do we?
No.
Right? So the point is that you have said things my question to you is you have said things in your testimony and in your interviews with law enforcement where you think that you may have done something or said something which contributed. Is that fair for me to say?
That's fair for you to say.
Okay.
That jury has been deliberating more than 20 hours. We continue to monitor the deliberations. And still ahead here on the debrief, the death penalty trial of Timothy Jones. The grandmother of the South Carolina man convicted of murdering his kids takes the stand for the defense. We recap that case after this. The South Carolina jury, which convicted Timothy Jones of murdering his 5 children, is now determining his punishment. The choices are either life in prison or the death penalty. The jury found Jones guilty of punishing his son to death and then systematically killing his other kids as they found out. The jury rejected an insanity defense and also rejected a chance to convict Jones with a conclusion he was mentally ill. This is the penalty phase, of course, and the defense now has the case. The defendant's grandmother talked about the toll on her family.
Do you want Tim Jr., put to death?
No, God, no. I love him. Her family's been through enough. God, I just don't think we can take anymore. This has broke us so bad. And that, I think, would just be the final nail in the coffin. I just don't think I can take anymore.
You still love Tim?
Oh, God, I love him with all my heart. I don't think when you love someone, it ever goes away.
Despite the jury's conviction without any mental health conclusion attached, the defense continued to press evidence of mental disorders in an attempt to save the life of Timothy Jones.
Mr. Jones meets the diagnostic criteria for schizophrenia, and I base that on my evaluations of him from 2014 until the present. And
what I do. What I do. What I do.
Him around the neck and pushed him against the wall as he held him there. Child has a bruise on his neck that resembles a thumb and a fingerprint.
When you talked to Natan, did he give you any story that differed at all with this?
No, sir, it was the exact same.
Who did he say did it?
His father.
When he told you this, what did you tell him?
All I could tell him was, I'm sorry.
The next day when Natan came to school, did you know the day this allegation is made, he goes home to his dad?
Yes, sir, he did.
How was Natan that next day?
He was very distant. He didn't want to say too much to anyone. He came in very quiet and sat down and ate his breakfast.
Following this incident, this DSS allegation, did you see any change in the defendant Tim Jones' communication or reaction with the school or with you specifically?
Yes, I did. The communication I had kind of cease and desist. There was no more communication from that point forward.
A teacher's assistant backed up many of those observations.
Who was the first person to see that bruising on Natan Jones?
Me. He came, and I'm almost positive it was just him that was in the room at the time. And he walked back, and I noticed the bruising on his neck. So I had asked him what happened. And he said that his dad had grabbed him by the throat and slammed him against the wall because he broke Eli's track. And I made him repeat it again because I couldn't believe that that's what he was telling me. I instantly just ran out of the room to go get one of our counselors.
Did Natan show you what happened?
Yes.
How did he show that to you?
You want me to show you? He said his dad went like this, and then slammed him against the wall.
And yet, it continued. An elementary school administrator testified about the characters of the 5 children.
And I apologize if I get a little emotional, but when they came in to us, Mara was going into 1st grade and Eli was going into kindergarten. Very sweet children, very loving children, made friends very easily. Mara was a little bit behind academically, so we immediately began to put some interventions in place with her to try to bring her up to where she needed. She was behind in reading and early literacy, early math skills, so we worked to bring her up to where she needed to be. And then Elias started out in kindergarten. I called him Eli, so I'll probably revert to that often because we were very close. And then the next school year, as they progressed on, then Natan came to us and entered kindergarten. So got to know Natan as well. They were wonderful children, made friends easily.
A babysitter to the children provided a similar description of them all.
Gabe, oh my goodness, he had a smile that would light up a room. He always wanted to be held all the time. So I would do nothing but hold him, and he just wanted to do everything his older brothers and sisters did. Whatever they did, he wanted to do it. Elaine, you know, she very bubbly, sweet baby, wanted to be held too. Just.
What can you tell us about the role of the siblings with those babies?
Mira was my little helper. She always wanted to help with the youngest kids, regardless if it was changing. Like, she always wanted to be like, I'll help you change Elaine. I want to help feed her. Eli was like that too. Just to know these kids and they would have an impact. No matter if you're having a bad day, just being around them.
Back during the beginning of the state's portion of this case, the state called one of the law enforcement officers who was with the defendant when the defendant led authorities to the place where he dumped the bodies of these children.
How far away was he from where the bags of these children were actually located?
Excuse me, you had to walk, a ways, but whenever he got out of the car, he didn't wander around. He just walked almost like directly, to a location that was in the brushy, again, kind of clear-cut area. And probably, if I can try to illustrate something, maybe about as far as where you're standing, Mr. Hubbard, to the back of the courtroom.
what was your responsibility as far as those bags that contain what we now know are the bodies of the children and that whole scene?
The state trooper that was there with us notified a coroner's office, and we ended up notifying 2 coroner's offices because we weren't even exactly sure what county we were even in. Quite a few officials from the local sheriff's office, the Alabama State Police came, and next thing I knew, there were 2 helicopters flying over us. They were dropping off Alabama State law enforcement officials in suits that were there. So obviously the word had got out that, 5 dead bodies of children had been located in this remote area of Alabama.
Turning now for analysis, our attorneys Paula Notari and Michael Bryant. So Paula, this is just a terribly sad case, but the bottom line is the jury needs to add up those aggravators and mitigators and try to figure out which side to come down here. Is it life in prison or is it a death sentence?
I think that given this part of the country, there's only needs one person to say no death penalty, and I think that they're gonna find that one person, particularly in light of the fact that there are experts saying that there was mental health issues. I mean, whether the jury believed that, whether that was sufficient, they've decided that wasn't enough to render, a not guilty verdict on the, or not insane, but that's a different standard. And I think that there is mitigation. I think they only need one juror, and I think they're going to find one juror in this case.
So the same sort of information, but they're just looking at it through a different standard at this stage. Michael, right. I wish we could talk about this, but we have to wrap up with this note here on the debrief. The jury in the Kellen Winslow case has issued a note saying they have a verdict on 4 of the 12 total counts. They're going to talk about that at 6 p.m. Eastern. We'll be live here on the Law and Crime Network. For those of you watching the debrief, it's time to wrap up. I'll be back with Michael in a moment on the network.